Good morning. Welcome all. Thank you for joining us this morning. I'm going to share with my successor, Rick Troy, who will be welcoming our guests as they filter in this morning, a couple minutes or a couple seconds actually before we start the webinar in earnest. And Rick will have a couple updates and housekeeping items. Rick?
Yeah, good morning, everyone. My pleasure to have you all join us today. As Janet said, I'm your new executive director at BOMA Detroit, and take this opportunity to thank Janet for all of her mentorship, and also to express my gratitude that she's going to be here through the end of the calendar year to get me through the weeds. We got to give a shout out to Belfour for sponsoring this webinar today on the subject of the end of open and obvious and this pending prompt pay legislation that our pair of Johns will be sharing with us today. There's one CE credit available, so make sure that we have your broker's license number. You can contact Janet or I on that. If you have questions during the webinar, please put them in the Q&A and we'll track them and we'll get to them at the end of the presentation. Let's see. Gentlemen, you ready to start?
Anytime.
All right, our guides for today are John Sear and John Hesberg of Kitch Attorneys and Counselors. Thank you, gentlemen, for being here. Take us away.
Thank you. I'll let I'll defer to the senior member on the panel.
Good morning. My name is John Hesberg, and I appreciate the opportunity to be with you this morning. We're going to talk a little bit about some changes in the law to open and obvious that have occurred and what that impact may mean to you, and then ultimately give you a few steps to consider for you and or your client. So next slide, please. This means pretty much you can ignore everything we say. And we don't take any responsibility for anything we say, because as lawyers, we have to have disclaimer language to begin. Next slide. So the changes in the law, as I'm sure you're aware, our Supreme Court in the state of Michigan has changed over the last few years, and we've gone from what has been viewed as a fairly conservative Supreme Court to one that I don't know if I would necessarily say liberal, but has taken a different view on some of the precedent that has existed over the years. And so along those lines, we end up with a pretty substantive change to the open and obvious law. We're going to talk about that. We're going to talk about liability claims as it pertains to slip and falls. Then my partner John Sear is going to talk about prompt pay bills and matters related to that. Next slide. Open and obvious. What is kind of the common understanding of open and obvious? It's basically if something is readily apparent to you and or should have been readily apparent to you, there was a legal defense for a claim relative to a slip and fall. And the precedent setting case, or the case everybody has referred to in the last 22 years, was the Lugo case. And we're not going to read all our slides, but this is how the law was pretty much for most of my career. And if you read this with me, in general, premises possessor owes a duty to an invitee to exercise reasonable care to protect the invitee from an unreasonable risk of harm. However, where the dangers, and the key language here, where the dangers are known to the invitee or are so obvious that the invitee might reasonably expect to discover them, the invitor, meaning the landowner, didn't have a duty to protect or warn the invitee unless he should anticipate the harm despite the knowledge of it on behalf of the invitee. So what did that really mean? Next slide. What it meant was if, and it really applied quite a bit in the black ice, snow, the obvious fall. The application of open and obvious was something that dealt with a question of duty. And why does that matter? Because if it was a question of duty, whether we owed a duty, meaning the landowner owed a duty, that was a question for the judge to decide. And when you look at a civil claim, there are issues that are decided as a matter of law by a judge, and then ultimately issues that are a matter of fact and application of the law to those facts by a lay jury. So for years, defense counsel, like John Sire and I, would be able to make the argument that an individual who fell on ice in February in Michigan knew or should have known that that ice was open and obvious. It would have been open and obvious to the reasonable person. The fact that they were texting on their phone and not looking, or the fact that they were running to their car and not paying attention to what they were doing, or they were talking with someone and really not looking down. That was not the landowner's fault. We could frequently get in front of a judge, show the weather, show pictures of what the ground looked like at the time, and ultimately a judge would decide whether or not the issue that caused the fall was open and obvious. That's very different than getting in front of a lay jury when you just never know what may be going on in the mind of a juror. So while there are conservative judges and there are less conservative judges, there was very good law in the state of Michigan. Even if you were in front of a less conservative trial court judge, when there would be a fall, you get in front of a judge who may not agree with you that it was open and obvious, but you could get up to the Court of Appeals and ultimately to the Michigan Supreme Court, which for quite a while was fairly conservative, and get that Supreme Court to look at the facts and say, nope, the trial court judge should have made a decision as a matter of law that it was open and obvious, that the landlord had, the issue was the apparent defect was open, obvious, and a reasonable person would have seen it. Next slide. Well, that law has now changed. Under Lugo, the most dangerous protections, you would look at it from the perspective of what would a person of ordinary intelligence upon casual inspection. You looked at it and you said, okay, objects that were trip hazards on the ground, a pothole, water on the floor. You see all of these things in these slides. Black ice and snow and ice were really the ones we saw in our practices the most, people slipping on ice in the winter. And those were cases where defendants, our clients, could look at it and we could counsel them and say, not quite sure what the trial court judge may do, not quite sure depending on what appellate group we got at the Court of Appeals level, but the Supreme Court had pretty strong law, and that if we had to take it all the way up, we were in a strong position. That has since changed. Next slide. When you look at the change in the law this past summer, toward the end of the July, Michigan Supreme Court basically took a prior decision of the Supreme Court, the Lugo decision, and a couple companion cases, and pretty much flipped them on their ear, essentially. And not only did they say, in simple terms, the court said, we're going to take the question of duty and move it from the judge, and we'll make it a question of fact for a juror. So when plaintiffs are looking at cases for a long time, they would look at trip and falls, slip and falls, and think they're not as good a case to bring because there's a good chance that we could have the case kicked out by the trial court judge or at least tied up in the Court of Appeals. When the Michigan Supreme Court reversed itself and threw away 22 years of precedent, it not only said that the law has changed, it applied retroactively, meaning that cases that were currently pending around the state of Michigan, no matter what state they were, and there were a number of cases, we've had several in our practice, that we have been successful at the trial court. The plaintiffs had appealed, anticipating a change in the law, and courts have come back and basically preemptorily reversed prior decisions and basically said, nope, these cases are all back, and now we're going to treat them under the new law and reverse any prior trial court decision. Next slide. So really, what exactly changed? It's the duty issue. The landowner now has a duty to protect the business invitee from an unreasonable risk. We had that duty before, but the question was, if it was open and obvious, could we get the judge to make that determination? And now we've got a shift where the open and obvious nature of a condition only factors into the jury's decision on whether we, the landlord, breached a duty to a plaintiff. So if you have a individual, now a business invitee, coming across a parking lot that's covered in a sheet of ice, under the prior decisions, if that person on a bright sunny day walked across and slipped on a sheet of ice, there's a good chance we could get that case dismissed. In fact, there's a good chance that a plaintiff lawyer wouldn't even bring that case. Now, plaintiff's bar can roll the dice and they can say, well, there's a chance that maybe I can get a jury to believe that the owner of that property breached their duty to keep that property safe, and that regardless of whether or not it was open and obvious, that'll just factor into who was more at fault, but it ultimately will get to a jury. And when something ultimately gets to a jury, there's a very significant chance that we could have a negative outcome from a jury. Specifically, we could get a negative verdict. Next slide. So what does it mean? More cases are being filed already. Cases that had been filed and won by defendants that were percolating through the Court of Appeals are now back at the trial court level and being litigated up to a jury trial. A lot more money is being spent litigating and defending these cases. And now that it's no longer a judge's decision on the issue of open and obvious, a lot of these cases are going to get tried. Next slide. So what can we do? We really need to be very vigilant in our training protocols. If we're defending an open and obvious slip and fall case, we're now going to be judged by was it reasonable? Were the actions taken by the landowner reasonable to prevent it, to upkeep? So when you look at the little picture on the slide, it's a little sign that you'll see on a floor walking into a store. Those types of things are going to become more and more important. Are we able, and common area video also likely going to be more important to show what we did was reasonable. Our snow and ice protocols, more often than not, with snow and ice cases, we get to business owners that don't document, don't take credit for the work they do to make their sidewalks safe, their driveways safe. So really what we're looking at is, and suggesting to you, that we take a breath, we look at, okay, what does this really mean? We've got to have staff that understand that that area that they are providing maintenance to, that they may be cleaning, needs to be cordoned off. We need signage up. All of the steps you'll see on this slide are steps that we're going to basically say to a lay jury, and juries are made up of your neighbors. They're made up of, they come from a pool of registered voters. So what we need is evidence to say to your neighbor that what we did was reasonable. Did we put signs up when we were providing maintenance or fixing a pothole? Did we educate our staff? Did we take the steps, and can we demonstrate that we took the steps to remove the snow, salt the area, and then conduct rounds to make sure that we have kept the area clear and safe? So when you look at open and obvious, and then I'm going to pass on to Mr. Sire, but when you look at the change in the law, it essentially went from a very defense-focused law where the judge could make a decision, and most judges would make a decision. We didn't always like them, but they would make the decision, to where that decision-making authority basically is now in the hands of the jury. So we're not able to get rid of cases before they go to a jury. Now juries are deciding whether or not issues were open and obvious, and whether or not we acted in a manner that was reasonable in light of those issues. So we need to be more vigilant and more careful. And if we do have an incident, make sure we can closely document everything that took place, because we're likely going to have to take that documentation, that video, those pictures, and blow them up in front of a jury, because the frequency of these cases is going up with this Supreme Court. Mr. Sire, I will pass on to you.
Wonderful. Thank you very much. I appreciate that. I appreciate the insights, and just, you know, as a quick follow-up, one of the other questions that you're going to have to do as a property manager or building owner is pay more attention to your contracts with the landscaping contractors, snow and ice removal, and also review your insurance programs, because that's going to become more of an issue than it had been in the past. But moving on to prompt pay, there are two bills right now: House Bill 4847, introduced by Representative Conlon, and then Senate Bill 451, introduced by Senator Lauer, to change the landscape in the construction contracting. It's supported by the Construction Association of Michigan, which is another trade organization made up primarily of smaller contractors, specialty trades, and other folks that are in the industry who feel like they've been taken advantage of over the years. And this is a series of bills that have been introduced several times over the years. And this time, they feel like they've got a great chance, because the legislature has changed. In every election, about a third of our legislators change over. So it's a matter of educating people. And part of what they have said is 38 states have these prompt pay bills, and Michigan doesn't, and we should. Well, it's a little misleading, because there are some states that have variations of prompt pay bills, but the easy one is to say there is no state in the country that has a prompt pay bill that has this language in it, that goes this far. Fundamentally, these bills, they contradict existing law, they invalidate the contracts that have already been negotiated, they change or even prohibit good industry practices, and then they just flat out contradict and eliminate protections under the Construction Lien Act. Now, the significant thing with these bills is, number one, they exclude public works and residential contracts. So if it's fewer than 7 units, if it's 7 units or larger than 7 units, then it would be considered commercial. But it applies to private commercial construction projects, which is everything else. Anything that's not a public work and it's not a residential project with fewer than 7 units, this bill will apply. Now, rather than me giving you a spin on the bill, I'm taking excerpts of actual language out of the bills to show you exactly what they say. So that first bullet point, that is exactly what the bill says. This subsection prohibits an owner from retaining a specified percentage of each progress payment and final payment that is due to a contractor, subcontractor, and supplier to ensure satisfactory performance under the contract. It can't get any more express than that. No retainage is permitted. Good industry practices typically will call for retainage. Sometimes it's 10%, sometimes it's 7%, 5%, but there is a retainage in the contract. That is industry standard. And that is to ensure and protect the owner to make sure that the project gets done. It gives the contractor that interest in coming back and finishing to get that retainage. Number one, both bills prohibit any retainage, period. Number two, it requires, and this is again, language right out of the bill, that a contract, any contract, must include a payment clause that obligates the owner to pay within 30 days after the end of the billing period. Okay, billing period ends 30 days. You have to pay. Now, under the Construction Lien Act, you as the owner have the right to demand a sworn statement under 570-1110. That is a very powerful document that's intended to protect the owner and inform the owner about the potential exposure to construction liens. There's no correlation here. There is no precondition on the payment or the timing of the payment period. So if you're asking for a sworn statement, the contractor doesn't have to give it to you under this prompt pay bill. So none of the supporting documentations, no lien waivers, no other receipts, no other information indicating where the money's going or that there's no exposure to liens in the event of payment or non-payment. So again, the next line is that a statement that the owner has sufficient funds or financing in place as of the effective date to complete the scope of work. Okay, number one, sometimes that's asking for proprietary information. Number two, it really ignores some forms of financing on certain larger projects. So that's part of the problem. And then on the flip side, it doesn't require the contractor to make any similar disclosures about their capital or liquidity or ability to do the work. So, there's a great imbalance there, considering that the contractors and the subcontractors and suppliers have lien rights. So if they don't get paid, they have the ability to record liens. And that's part of the problem with these bills is the inconsistency with the Lien Act, because then you get to the third bullet point. And that is, again, this is right out of the bills. And this is what a contract must include. And if the contract doesn't include it, the statute imposes it. And that's the 12% per annum on each payment that begins running on the 31st day. So one day after the 30-day period for payment, that 12% interest starts running. What's really interesting is that as you continue down, any amount of interest that remains unpaid at the end of any 30-day period must be added to the principal amount of the debt, and thereafter interest penalties must accrue on that amount. That is compounded interest. So if you pay on the 31st day, assuming that's how you do it, you're going to be paying 12% interest on 12% interest on 12% interest. So it's just untenable the way that it's stated right now. Plus, if your contractor delays providing the sworn statement, because the Lien Act says an owner can withhold payment until a contractor provides a sworn statement, So now you've got the contractor delaying providing a sworn statement, but under this bill is accruing 12% interest on the unpaid amount. So you've got a huge untenable conflict between those two bills, or between the law and these bills, that makes this bill, both of them, just unworkable. So as we continue, there's even more fun things that are in the bill. And again, this is straight out of the language that if there's a dispute, let's say you do get the invoice, you're looking at it, and you say, I don't think that you have finished all of the work that you're billing me for. And the contractor says, I disagree. Well, if you, the owner, say, well, I'm willing to pay you half, because that's what I can verify that you've completed during this pay period. That's not good enough. You have to take that other half that is in dispute and put it in an interest-bearing account, separate. So you're taking that money and encumbering that money and putting it in an account until the money, or there's a settlement, or a court or arbitrator determines how the funds are to be dispersed. So now you've got a contractor who can assert that he's entitled to payment of X amount, and there's a good faith, legitimate dispute, but the owner now has to encumber all of those funds and put it into a separate interest-bearing account until there's either an agreement reached or an arbitration or litigation. Again, that's just untenable from the beginning. But then when you go through the litigation or the arbitration, they're very generous and say, if it's determined by a court of competent jurisdiction or an arbitrator that a payment withheld was not withheld in good faith, the court or arbitrator shall award reasonable attorney's fees to the prevailing party. Well, that's a little misleading that it says the prevailing party, because there's only one prevailing party, because they're making a determination as to whether or not the owner is withholding unreasonably or wrongly. There is no corollary that if it's determined that the owner is correctly withholding the money, that they're now the prevailing party. That's not the way it's worded. It's only worded in a way that the contractor will get their attorney's fees. So then when we move on, it continues. I mean, the hits keep coming. So now you're looking at the statute, not a contract. This is what is mandated by the statute, that the contractor is entitled to submit to the owner for payments at the end of the billing period for one or more of the following. Now, this is in the statute, not the contract. Work already commenced, but not fully completed if the invoice work will be completed by the end of the billing period. Some contracts allow that, but this would be a matter of law. Secondly, materials already supplied to the project. Now, this is where it gets a little subtle. They're supplied, they're not yet incorporated. You get a drop ship of significant materials onto the site, it becomes a trip hazard. The contractor is allowed to bill for it. By law, under this bill, they would be allowed to drop ship or a lot of materials that aren't necessarily needed to the site because they're not yet ready to be incorporated into the project, but they're allowed to bill. So now you've got this incentive to start crowding the site and shipping a whole lot of materials onto the site, and then not just creating that trip hazard, but also insurable risks. Now, a lot of times in a contract, the parties will make arrangements with regard to pencil copies of invoices, interim invoices, review periods, and materials that may be stored off-site. and whether or not the owner is going to acknowledge and pay for them in advance of the materials being brought to the site, that's a matter of contract. That is a risk allocation between the owner and the contractor. It does not belong in a statute where it's mandated that the contractor can bill and be paid for materials supplied but not yet incorporated into the project. Then you get the timing again, this 30-day notice, where it's 30 days at the end of the billing period or 30 days after delivery of the invoice, whichever's later. So if they don't invoice you and you just get a bill, or you've got this time period that runs, you've got 30 days. And again, there's no requirement for any conditions precedent, no requirement for supporting documentation. There's no requirement for other documents or verification or waivers or anything like that. It's a 30-day hard period for the contract or for the owner to pay and invoice. Now, this is where the next bullet points where it gets a little weird, because it talks about a retainage. Well, we looked at the language earlier that says the owner is not entitled to retain anything. Now you introduce this concept of retainage by an owner that can't be more than 10%, or after the work is 50% completed, 0. So at the end, you're only holding 5%. So you've got these internal inconsistencies within the bill itself that raises this notion of a stepped retainage, which again is a matter of contract. That a lot of contracts will reduce retainage at 50% completion, but it depends on the owner, it depends on the project, and it depends on what the parties are able to negotiate. But having something in here in this bill where it's completely inconsistent with an earlier provision in the bill, it's almost nonsensical at that point. And then you've got the shorter time period than the 30 days. You've got 10 days actually from the time that you receive the invoice to review it and object to it. Now remember, when you've got that issue of the objection, whatever the objected amount is, that goes into an interest-bearing account. So, you know, the protections you've got are really gone at this point. So you get an invoice, you got 10 days to object to it. But even if you object to it, that money's encumbered because the objected portion, the non-agreed portion, is going into an interest-bearing account. So the burden and the risk on the owner for these bills is kind of frightening. Now, these provisions that I've gone through are actual language out of the bills. There's a lot more issues when you dive down deeper into the bills. We're not necessarily going to go all the way into all of the subtle nuances here, but there are quite a few that talk about or that have an impact on title insurance, have an impact on lenders, because not many lenders are capable of processing payments within 30 days. There are a lot of institutional owners that the levels of review that the invoice has to go through, whether it's on-site inspections or the documentation. I mean, that's completely missing from these bills, is the notion of a sworn statement, lien waivers. If it's a cost-plus contract, any of the additional information from the subcontractors, including their lien waivers and any other proofs of payment or costs that the contractor has incurred when you're paying on a cost-plus basis. So none of that documentation is a condition for payment under these bills. So the owner just becomes a cash register at this point under these bills, and that's what creates the potential for it to, I mean, have a serious negative effect on whether or not any construction work can really be done. So what do? They are still bills. The Senate bill is in the Labor Committee, and the House bill is in the Committee on Economic Development. So what you can do is contact your legislator and let them know that, this bill may have a, laudatory name, prompt payment. Well, how can you avoid or oppose prompt payment? What, do you want a delay payment? No, that's not it. The name of the bill is misleading. And a lot of the information that's out there regarding the bill is misleading. But the biggest problem from an owner's perspective is you've got the protections already of the Construction Lien Act, and these bills would gut that protection. It would essentially eliminate the protections that the owner has with regard to insisting on a sworn statement and using the sworn statement to inform yourselves, the owners, of who's working on the project, how much has been paid, how have they been paid, how's the contractor handling their subcontracts, and how are they managing the money. So with that sworn statement, it gives you a lot of information about what your exposure is to potential construction liens. And if you get notices of furnishing, there's different coordination that you need to do in order to make sure that those subcontractors are getting paid. But the sworn statement is like the playbill. It's the program that you get when you go to a game. I mean, it tells you who the players are, who's going to be showing up on your job, how much they're entitled to be paid, how much they've been paid. So without that sworn statement, you're at a great disadvantage. And these bills eliminate your ability to request that sworn statement, because when you do and the contractor doesn't provide it, you're paying penalty interest of 12%, and it's potentially compound 12%, until the amount's paid. So the one is contact your legislature, and second is contact any legislator. So if you're where you live, your legislator is one person, and where you work, your legislator is different, contact them both. And if there's other legislators that you are familiar with, you're aware of, mention it to them. Tell them that these bills are not what they purport to be. Some, not every legislator has read these bills. Not every legislature reads all of the bills that are introduced. I mean, it's a massive task. So the legislators rely on getting information and feedback from their constituents. So this is what we're asking, and what we're suggesting is that everybody take some time to reach out to a legislator, and don't wait, because this is an odd year. A lot of times the legislative session will last out into December, late into December, but because next year is an election year, there are some elections coming up, there's primaries coming up, and that caused the legislator to truncate their session, and they're going to be wrapping up in early November rather than the end of December. So the sooner that you let the legislators know that these bills are problems and that they have irreconcilable conflicts and they are untenable in the construction industry, the better off everyone will be. So we need to get the word out, and the links there is, if you don't know who your representative is, there's a link that you can click on that they will take you there, and you can put in your zip code, your address, and the same with your senator. And it will tell you not just who they are, but it'll give, typically pull up their page in either the House or the Senate website, so that you're able to send a direct message to them and let them know that these bills, House Bill 4847 and Senate Bill 451, they're not good policy. They have negative repercussions. They conflict with good industry practices, and they gut existing protections for owners, while not recognizing that contractors and subcontractors already have lien rights under the same statute, the same Construction Lien Act. They have these protections. If they don't use them, if they don't use the protections of the Lien Act in ways that they're entitled to under the law, that shouldn't justify the creation of a new law that creates more problems, contradictions, and impossibilities for building owners, building managers, and people wanting to develop property. So I think now that we've gone through that, I wanted to see if there were any questions. We left a fair amount of time because I want to make sure that if there are any questions or concerns, that we had the ability to address them. I don't know if
We currently do not have any questions in the Q&A.
all right. Well, I will say that on the House bill and Senate bill, we will be talking to legislators coming up. And if there's anyone that has any, wants to do an introduction or just suggest, we've got some materials that BOMA has available that we can share with them. And, that will be some of the resources that they can provide to their legislator.
John, we have a question. Question is, are we seeing any increase in premise liability insurance now with the change?
Yes. As I can tell you, having represented or having the privilege to represent clients around the country, and their property and casualty insurance going up, the property insurance increases in Michigan are significant and a direct reflection on the change in the court and the pretty much destruction of open and obvious. John Sire made an excellent point as he was beginning. It is important to take a look at your agreements with your vendors. One of the candidly, one of the most disheartening things as a defense lawyer is to look at a contract we have with a service provider who failed to do something, failed to properly salt an area, failed to fix a piece of pavement or concrete properly, and my client gets sued over it. And I look at the agreement that my client has with the third-party vendor, and I find not only is there indemnification, but the indemnification is my client indemnifying the vendor. It goes the wrong way. When you look, contracts are boring, just are, but you need to make sure that you're not just having staff sign off on something without taking a look at it. If you're looking at a vendor who is unwilling to stand up and provide you with coverage for the services that they're providing, maybe it's time to look for a different vendor. At the very least, do not indemnify that snowplow company. They should be indemnifying us. So take an extra couple minutes, look at that indemnification language, make sure that at a minimum it's neutral, but it should really protect you and not the other way.
The only thing I'll take exception to is when you said contracts are boring. Unfortunately, that's the world, one of the worlds I live. Now,
I need to say no more.
I did see another question on, is there a legislative fix possible for the premises liability situation?
Sure, but not with this legislature. At this point, we have a Democrat-controlled a Democratic governor, Democrat-controlled legislature, and a Democrat-controlled Supreme Court. It would be difficult to envision, from my perspective, that a legislative fix will happen anytime. In fact, I'm not sure. I'm not aware of any effort at this point. It's just not viable given the state of the House, Senate, Governor, Supreme Court.
Okay. Now, and I also see a question about the possibility of contracting around the prompt pay legislation. And the problem with that is that the language of the statute is mandatory, or the language of the bill, I have to be careful, is mandatory and will supersede any contract that is any contract provisions that's to the contrary. So if you do try to contract around it, attempt to withhold retainage, that would then be subject to the 30 days and the 12% interest. So that's the problem. Well, among the several problems with these bills is they rewrite contracts, they rewrite industry practices, they rewrite and completely change what the parties may agree on, whether it's good industry practices or their typical practice. So yeah, that's part of the problem. And there, on the open and obvious, there was a question about the if you have any of the scenarios or the summaries of the cases that prompted the change, and why the Supreme Court would make that change to the law now.
We certainly can provide BOMA with a summary of the Supreme Court's decision, and that's something we can do following this presentation. In fact, I believe we've sent out a couple of summaries previously, and we're happy to share those with the attendees. The why, I believe that it was a from what I understand, a pretty strong push by the personal injury bar that was ultimately successful.
Okay. Now there's a question and an observation where they say it sounds like the concept of open and obvious is still relevant, which it is. And says, however, since its relevance and impact is now going to be decided by a jury in lieu of a judge, that's where the main problem is now, correct?
That's absolutely correct. The amount of money it will take to defend a claim under Lugo was significantly less than the amount of money it will take to defend that claim up to and including a jury trial. The certainty is also significantly changed, where the law was fairly straightforward before Lugo as to what a judge would decide, and there was a great deal of case law that followed Lugo that allowed you, in most cases, to fit your fact pattern into a case that had already been settled, and that prompted personal injury attorneys to be very selective in the cases that they brought, because the chances were that that fact pattern had been seen by some court of appeals, and a ruling in more cases than not in favor of defendants had already taken place. So the cases weren't being brought. Now, pretty much Wild West. Just don't know what a jury is going to decide. So the cost goes up significantly in defense costs for lawyers. attorney's fees, and the uncertainty goes dramatically up because I don't, even the best trial lawyer is going to get hit in a case where they think that the facts are very much in their favor. You just don't know.
There's another strategy question about that. Can't building owners just put up a sign at the building that say, enter at your own risk, and try and negate all of it?
Sure, but that still goes to a jury. Ultimately, is that sign enough? By the time you get to the jury, you've spent a great deal of time in defense costs. It used to be that a judge would look and say, you're right, that sign was enough. However, that's no longer the case. Now the jury just considers whether that sign was enough and or what percent of comparative negligence does that place on the person who was injured, leaving the balance on the defendant. So no, you can't just put a sign up. You should put a sign up depending on what the issues are and what you're warning about, but it ultimately becomes a question of fact for the jury as to whether or not you breached your duty.
So now, instead of it being a threshold question, I mean, open and obvious is a jury question. So all
Exactly
the
right.
actions, yeah, you're going to be rolling the dice.
Do we have any further questions? I'd like to thank both John and John for joining us this morning and providing these great updates on two really impactful issues that have taken further protections away from property owners. So with that, the recording will be available along with the presentation and the decision that John mentioned on the open and obvious. So with that, have a great afternoon, and thanks again for joining us.
Thank you.
Thanks very much.
Take care. We are done.
I lost my camera. The heck?